Good afternoon. I'm James Cooper, Professor of Law at George Mason University Antonin Scalia Law School and the Director of the Program on Economics and Privacy, what we like to call PEP. PEP is a division of the Law and Economics Center, and it's devoted to providing rigorous economic analysis of privacy, data security, and other competition and consumer protection issues surrounding the digital economy. Last month, the FTC issued an advance notice of proposed rulemaking on commercial surveillance and data security. This ANPRM is sweeping in scope, ranges from cookies and targeted ads to the discriminatory use of algorithms. And it's the first major employment of its inherent rulemaking authority, so-called Magnuson-Moss rulemaking authority, in many years. Perhaps unsurprisingly, this ANPRM was issued by a split commission, with the Democratic majority commissioners all supporting the issuance of this proposed rule and the two Republican commissioners against, with each writing separate statements. So today we are lucky to have a fantastic group of experts to discuss this issue. First, Svetlana Gans is a partner at the Washington, D.C. office of Gibson, Dunn, and Crutcher. Before joining Gibson Dunn, Svetlana was the Vice President and Associate General Counsel at NCTA, where she helped lead the association's consumer protection and competition policy work. And prior to her stint at NCTA, Svetlana served as the Chief of Staff for Acting Chairman, FTC Chairman Maureen Olhausen. Justin Brookman is the Director of Technology Policy for Consumer Reports. And prior to joining Consumer Reports, Justin was the Policy Director of the Federal Trade Commission's Office of Technology Research and Investigation. And prior to that, he was the Director of Consumer Privacy at the Center for Democracy and Technology. Finally, last but not least, we have Adam Kovacevich. He's the founder and CEO of the Chamber of Progress, a new center-left tech industry policy coalition promoting technology's progressive future. Adam most recently served as the head of North America and Asia Pacific Government Relations for Lime, the scooter mobility company. And prior to that, Adam led Google's policy strategy and external affairs team. So a quick note for the audience. If you have questions, please put them into the Q&A function and I'll take a look. And we will try to reserve some time at the end of this to let the panelists address these questions. So without any further delay, let's get started. So Svetlana, I want to turn to you first. Can you just provide us, kind of set the stage a little bit here, provide us a little background on this advance notice of proposed rulemaking, you know, what it says, and maybe just a brief overview of the divisions of the commission in issuing this?
Sure, will do. Thanks, James, for having us, and to Andrew for all the back-end assistance. And it's great to be here with Justin and Adam at this great event. So thanks for having us. So as James said, on August 11th, the FTC issued its long-anticipated advance notice of proposed rulemaking on corporate commercial surveillance practices. According to the FTC's website, commercial surveillance is the business of collecting, analyzing, and profiting from information about people. The FTC stated that the volume of data collected exposes people to identity thieves and hackers. FTC also says mass surveillance has heightened the risks and stakes of errors, deception, manipulation, and other abuses. The FTC is asking the public to weigh in on whether new privacy, data security, and algorithmic bias rules are necessary to protect people's privacy in the information commercial surveillance economy. So the FTC asked 95 questions for public comment to try to get to the bottom of these general themes. Specifically, the advance notice includes questions on how commercial surveillance practices or lax data security measures harm consumers, children, and teenagers, how the Commission should balance the costs and benefits of current practices and potential regulation, how the Commission should regulate data security, the collection, use, retention and transfer of data, consumer data, automated decision-making systems, discrimination based on protected categories, consumer consent, notice, transparency, and disclosure. The FTC's fact sheet stated that the FTC is generally interested in how data is collected, analyzed, and monetized. The public comment period will close on October 21st. As of this morning, the FTC docket indicates that over 123,000 public comments have been submitted so far, and we still have about 6 more weeks until the public comment process closes. As James mentioned, tomorrow the FTC will be convening a public forum to further discuss the issues in its advance notice. The forum will feature commissioner remarks, staff presentations, 2 panels including industry and consumer advocate perspectives, as well as public remarks starting at about 5 p.m. I'll turn it back to you, James.
Great. Thanks for thanks for providing that background. And as you mentioned, tomorrow the FTC will be convening a public forum, but I think this is a preview of that, and hopefully we'll provide some our thoughts here. The panelist thoughts here will provide some great insight that perhaps can be people can employ tomorrow. So I have kind of a big picture question, and I want to start off with you, Adam. Do we even need a rule here? In the sense that the FTC has been involved in privacy and data security issues since the late 1990s. I believe the first case was something called GeoCities, where they've used their Section 5 approach, using deception primarily, but also using their unfairness authority to go after privacy, lies about privacy or harmful privacy practices. They also employ COPPA. They have enforcement authority under COPPA, which they've used recently quite a lot for some fairly large fines. So what would a rule add to the FTC's current case-by-case approach? I mean, is this going to improve the current situation or make things worse? Are there gaps that need to be filled in? So Adam, let me turn it over to you to answer that.
Yeah, I do think there are gaps. I think the question of the FTC's legal authority here to issue rules is doubtlessly going to be litigated, right? I also expect some portion of the comments, particularly from traditional business groups and right-leaning groups, to focus their comments on what they see as the FTC's lack of authority to do these rules. Our group, Chamber of Progress, is not a traditional business group in that respect. Right now, we've looked at another agency in another area, and that's the SEC under Chair Gary Gensler, and how they've approached crypto regulation. And one of the things that the SEC has done with respect to crypto regulation is, rather than actually issuing clear rules about how crypto digital commodities should be regulated, inviting public comment on those rules, they have instead adopted a kind of a regulation through litigation approach without really ever warning companies about what they consider to be inappropriate practice or not. That's denied businesses, in the case of the SEC and crypto, the guidance they need to stay on the right side of the rules, not create, and it's also denied people a chance for kind of an open, transparent venue for input. So I personally, and I think our organization, we support the Commission's efforts, the FTC's efforts here, to create baseline rules. We think that consumers benefit when businesses have clear rules of operation, and when the tech industry is particularly incentivized to undertake and explore stronger data protection practices. So I think credit where it's due. Good for the FTC for writing the ANPRM. That's a lot of questions, 95 questions, but good for them for seeking that kind of input, because other agencies aren't doing that. But then the question becomes, and we'll get into this, are they really listening to what they're going to hear? The ANPRM is a document a bit at war with itself, vacillating between just asking questions and kind of hinting that it already knows the answers that it wants to arrive at, right? I think because of the process objections from both of the Republican commissioners, my expectation is that the NPRM to the next stage, and any final rule will probably only be supported by the Democratic commissioners. But that doesn't mean that the Democratic majority should or will necessarily support a kind of maximalist position of embracing every idea in the ANPRM or embrace every suggested rule here. I think the best way forward for the Democratic majority is to build political support for rules beyond the mere legal question, is to focus on the areas of greatest substantive policy consensus, and we can get more into that as this conversation continues.
So, Justin, what do you think? I'll pose the same question to you as to Adam, and I want to. Something Adam mentioned is about guidance and clear, letting businesses. A rule is good, but one of the justifications for rule often is, well, we need to provide clear guidance to business. Of course, as I mentioned before, the FTC has been in this business for 20 years. They've written numerous reports, some of which, Justin, you're probably involved in writing. Are businesses really at a loss for what the FTC considers a violation of the law? And the same question to you is: is a rule a good thing, or if the case by case that the FTC has been doing for the last 2 decades plus good enough?
Yeah, I think a rule is a good idea. Privacy is a really nuanced idea. You've seen the legislation to regulate it with the ad papa, the federal bill that's being considered. It's like 132 pages long, whereas the FTC Section 5 authority is like a paragraph. And so it's a really powerful tool, but it's a very blunt instrument. And so I think having clearer rules for everyone's a good idea. The FTC has done dozens of cases, but most of their cases settle. And so it's not entirely clear, even if a case settles, if that is settled law. The FTC recently sued a company called Chava, a data broker, for selling companies' personal geolocation records. This is something that dozens and dozens of companies do, and it's gone on for a long time. Is that illegal today? It's not entirely clear. We might get some answers in a number of years. In the meantime, there's a lot of uncertainty, and a lot of companies are doing the same thing. And even if a judgment does come down, it might be limited to, well, it's only because they didn't fuzz the data in certain sensitive places, or they de-identified in certain ways. Also, the FTC is just really resource constrained. They only have really the capacity to bring like 10 cases a year, right? And privacy is very sweeping and covers lots of different areas. And then Adam rightly noted, like, for companies too, right? They should have fair notice. And sometimes the FTC's actions have been challenged on this idea that we don't have fair notice about what is actually illegal. And then the second piece of it is, I would say, is there's consequences, right? Right now, when a company violates the FTC Act or is found or settles with the FTC, there's usually no consequences besides like signing an agreement not to do it again, right? The FTC does not have penalty authority. And so the FTC has done like 100 security cases, right? And saying like, yes, you need to use reasonable data security cases, but I don't think that that's really been good enough, because right now, like, if a company gets caught, they just sign an agreement. Okay, we're not going to do that anymore. Whereas if there's a rule, you can say, okay, here's the clear rule, and if you violate it, then there are penalties, and then I think companies have more incentives to actually follow what the law is.
Okay, so I just want to follow up with you, Justin, just a minute on that. I mean, I think you bring up a good question about, or I'm sorry, two good points that often are pointed to with respect to why rules are better than the case by case, especially in the FTCs. So one is these are all brought with no money, almost all brought administratively. So you get a settlement that puts you under order. Now, that said, we have seen sweeping. Once you're under order, you kind of have the sword of Damocles hanging over you. Ask Facebook about that, and Google paid, not an insignificant amount of money, a couple $100 million, I think, for something. But I mean, I understand that. One of the things you talked about, though, was the resource constraints of the FTC. I'm wondering, okay, so they can bring 10 cases a year under Section 5. Does the fact now that instead of it being Section 5, that it's a rule, does that alleviate resource constraints? In the sense, is that if they can only bring 10 cases under Section 5, are they still, if you have a privacy rule, you're still going to only be able to bring 10 cases, or does somehow having a rule enhance or magnify or multiply your current resources in some ways? Is that still going to be an issue?
No, it's a fair question, and probably in the short term, it actually makes it harder, right? Because you need to suck off some of the resources to actually write the rule. They have the hearings and all this very convoluted process. In the long term, though, I think it would make bringing a case a lot easier, right? Right now, they need to go to court to say, to Kolchava, for example, they need to prove that this is an unfair business practice. Whereas if they had written a rule saying, okay, selling of geolocation data under scenarios A, B, and C is illegal, then it's a lot easier for them to bring that case. And also, I think with the fact that they have the ability to get penalties, companies are going to be more incentivized to settle. And so like, they don't have to, it's not a long shot seeing if a judge is going to actually agree to their interpretation of what is today, admittedly, a very broad and vague in many ways statute.
Yeah, I think that's a fair point, that there are probably evidentiary benefits of, if this is basically, to use the antitrust analogy, if naked collusion between, if two people get together in a smoky room to set prices, you don't have as much evidentiary hurdles to clear as you would under a full-blown rule of reason case where you have to prove costs and benefits. So fair point. Well, what I want to, and Svetlana, I haven't given you, I was going to turn to you next anyway. So what I'm going to do, I have a specific question for you, kind of pivoting to, and Adam had talked about this. He talked about, we're using all this jargon, ANPRM and NPRM. What this leads to this kind of vagary of the FTC Act, that the FTC doesn't have what is called notice, normal notice and comment rulemaking. It's operating under this 1970s Mag-Moss, what I talked about in the introduction, Mag-Moss rulemaking. So I wanted to ask you, as someone who's obviously worked on these areas at the FTC and in private practice, what are the differences? And this is not an admin law class, but just sort of broadly why we're talking about advance notice of proposed rulemaking versus notice of proposed rulemaking, and then we're having this public fora tomorrow. What is different about the Mag-Moss process than kind of the normal rulemaking that we think about? So that's the direct question I wanted to have to you, but I also wanted to give you a chance to weigh in on the whether you think a rule is a good, leaving aside the substance of the rule, which we'll get into, but whether or not a rule has benefits over a case-by-case enforcement approach. I mean, if you want to. I mean, obviously, Adam and Justin have covered that, but I wanted to give you a chance as well.
Great, thanks, James. I guess let me take the Mag-Moss question first. So as you mentioned, a lot of acronyms. So the Magnuson-Moss rulemaking process is a type of hybrid rulemaking process where Congress imposed additional procedural requirements to ensure transparency and due process. So it is APA rulemaking plus. The Magnuson-Moss Act allows the FTC to promulgate rules which, quote, define with specificity acts or practices which are unfair or deceptive acts or practices in or affecting commerce, end quote. So in addition to the normal notice and comment APA requirements, the Magnuson-Moss Act has several additional procedural elements. For example, the advance notice of proposed rulemaking, which is what the FTC issued in August, that would go before the notice of proposed rulemaking. The advance notice is to be published in the Federal Register and submitted to congressional committees, which the FTC has done here. After the advance notice, the FTC must issue a notice of proposed rulemaking that must state with particularity the text of the rule, including any alternatives which the Commission proposes to promulgate, and the reasons for any proposed rule must be submitted for congressional oversight and review in advance of public dissemination. So that is something different between the APA process and the Mag-Moss process. Congress must have advance notice of any proposed rule. Another key difference is informal hearings, if requested, with several additional procedural requirements, including cross-examination by interested parties. So here it will be interesting because Chair Khan has changed or streamlined Section 18 rulemaking procedures in July of last year, including with respect to the hearings and the staff report requirements. So it will be interesting to see how those streamlined processes will look how they will be this coming for privacy rulemaking. Typically, the staff report must contain recommendations, which is published in the Federal Register with at least 60 days advance notice. There must also be a statement of basis and purpose with several requirements, and then a final regulatory analysis. So suffice it to say that it will be a lengthy and complicated process. That is why typically MAG-MOS rulemaking fell out of favor several decades ago. And in fact, only 7 FTC rules and 9 amendments have been issued under Magnuson-Moss. And those took on average over 5 years to issue, according to research. So it will be interesting to see how the July 1st streamlining reforms will impact the timeline for the privacy rulemaking. Comparing the 5-year time span with MAG-MOS rulemaking, typically under APA notice and comment procedures, the process in average takes less than 1 year to complete. So that should be interesting to see what happens. Now, you had asked whether the FTC's advance notice complies with Section 18 requirements. I guess that will remain to be seen. Commissioner Phillips stated in his dissent that the advance notice failed the Section 18 requirements because it did not identify the areas of focus, FTC's objective, and possible regulatory alternatives. In my mind, we will see kind of how the process progresses and what additional mechanisms the FTC will employ in this rulemaking. So I'll turn it back over to you.
Great. Thanks, Svetlana, for I mean, just a really nice summary of the key distinctions between the MAG-MOS and the normal APA rulemaking. And as you correctly noted, and there's already, I mean, there's sort of a big picture question as to whether the FTC even have the authority to issue these sorts of rules. And then there's kind of under that subheading is, as Commissioner Phillips brought up, the notion that the ANPRM, by asking 95 plus questions and kind of sweeping, I think Adam said it's a document perhaps at war with itself, where it doesn't necessarily lay a rule out. It just says these are a lot of things we're thinking about and maybe previews the answers to some of those, but doesn't necessarily lay out a clear regulatory, a clear rule or alternatives, which is I think what the statute says, alternatives considered or what you're considering, that in itself may not be following the procedures that its own internal procedures under Section 18, which I'm sure that we'll all become admin law experts as this proceeds. So I want to turn now to as I said, there's a lot here on the procedure and a lot of admin law issues that I think will probably be very key going forward. But I want to now turn to some of the substance. I mean, this is the program on economics and privacy. So I want to turn a little bit onto some of the substance of privacy. So, and there's a large focus. I mean, the title of the document is commercial surveillance, and there's a large focus in the ANPRM on online tracking, on things that facilitate behavioral or interest-based advertising. It explicitly says that the FTC is I use the scare quotes, concerned that firms might actually be monetizing consumer information. And I think that's what they say, is that they use it to make their products better, but they also are using it to make money, and we're concerned about that. So I'd like to, Justin, I'll turn to you, but I want to give everyone a chance to weigh in, but I'll turn to you first. When we think about this focus here on behavioral advertising, behavioral targeting, tracking, cookies, pixels, that sort of thing, what are the privacy harms that you see flowing from this? I mean, do you see this as a major privacy harm, something that needs to be addressed by rulemaking? So Justin, I'll tee it up for you, but then I want to let Adam and Svetlana weigh in as well.
Yeah, I mean, I think it has to. I mean, I think, online targeting has like driven the privacy debate going back, I think, to like the 1990s. Still, even today, like all the stories you'll see in like the New York Times or Vice, like we found this app and it's sharing data with Google and Facebook. I think that's people's mental model for privacy. That the computer is the vehicle through which like a lot of these privacy violations happen. And I think that's probably quite accurate. I think there are a variety of reasons why you could want to care about it, why you think it's harmful. You could be worried about, imbalance of information. Companies collect more data about you. They can price discriminate. They can capture more of a consumer surplus. You can worry about discrimination. Maybe this data is being used in discriminatory ways. You could worry about privacy on shared devices, right? People share a device, and like you can see what the other person is doing. And I've certainly had Christmas ruined a number of times by knowing what had been purchased for me. You could be worried about security, like all these companies collecting logs about all the things that you do. It could get lost, it could be exposed, it could be embarrassing. So I think there are a lot of potential harms, but I think for most people, it's just like, it goes back to the fundamental right to be left alone. I want to just browse the web, like not have everyone, someone like 20 companies on my shoulder watching everything that I do. Like there is some a desire for seclusion. Like so when you're reading a book in the library, you're just reading a book in the library. That's not how it is online. And I think people think it should be more. And I think, other privacy statutes, right, they're not necessarily predicated upon like some secondary harm, like the Wiretap Act. You don't need to prove, like it says, like people can't listen to your conversation. You don't need to prove why that's harmful. Like, why is that bad? What do you lose from that? No, you expect to have a conversation without people listening in. And I think for the same reason, people want to be able to browse the internet without having dozens of people listening in. And I think that's what people want. That's, I think, driven some of the state legislation we've seen. This so drove, I think, the federal bill that we've seen, and I think it justifiably is one of the main focuses of the privacy rule.
Thanks, Justin. So Adam, let me turn to you. Same question. Big focus
Sure.
on this and on online tracking, behavioral targeting, things that facilitate interest-based advertising. You heard what Justin had to say. One thing I think I'm capturing what broadly what Justin said. You can correct me if I'm wrong, Justin. But that there's kind of this, we all have this right to privacy, or we all enjoy privacy, and part of that is browsing the web without being tracked. But on the other side of that is a lot of that being tracked allows us to have the free web as it is. So Adam, I want to throw it out to you. What are your thoughts, and what are your thoughts on the benefit side here as well?
Yeah, I think consumer behavior here shows that consumers' views are complicated on this question. So, for example, I think that there are now fairly global regulatory norms that have been really primarily advanced through the GDPR around companies adhering to the principle of data minimization, collecting a minimal amount of data to make their services work, purpose specification, using it for the purpose that it's specified. And frankly, I don't think those are now so ingrained in most companies' behavior because of compliance with GDPR, to the extent that those principles would be embedded in FTC rules here. I think you'd find a fair amount of support, or at least not much objection, because again, those would become norms. I do think when I said earlier the ANPRM is a little bit at war with itself between asking questions versus having the answers, the framing of it is focused on commercial surveillance, that I think is one of those examples of kind of having its own answers, right? Which is to say, it's the title, the name of it are, I think, implying that that kind of data collection is de facto bad. And that's not, I think, consistent with the ways that consumers use services. Data-driven services are used every day to delight people, delight consumers with sort of beneficial services. Data analysis can often be used for beneficial purposes like combating discriminations, right? You look at the things like the Zillow's estimate, right? It can be a tool for countering racial bias in assessment. So I think to paint all data collection analytics with a broad brush is not really where most consumers are. You look at things like proposal by Accountable Tech last year to ban all targeted advertising, and that's not something that I think is where kind of mainstream support is, even among members of Congress, particularly because I think many have recognized that targeted advertising done safely and appropriately can play a critical role in supporting consumers, supporting creators, supporting news publishers, and frankly, supporting more competition, right, between players. And so I think that, you know, again, to the credit of the ANPRM, the questions that asked
Have we lost Adam?
I lost him.
Yeah, I did too. So it's not me. Okay, well, as we try to reestablish contact contact with Adam, Svetlana, let me let you jump in, and if we get Adam back, we can see him. I don't know. I see a photo of Adam. Adam, are you there? Okay, so Svetlana, what let me give you a chance to weigh in on this as far as Adam is back. Adam, can you hear us?
Sorry about that. Yeah, sorry about that.
Not a problem. You were waxing poetic on on
my camera thought I was going on too long.
Yeah, yeah. So continue with your thoughts on the ANPRM's focus.
No, I think to its credit, it asks 95 questions. Those questions are nuanced. It asks about different aspects. For example, I think there's a lot of support. There will be a lot of support for restricting uses of data that can be used to discriminate against people in housing and education and jobs and other opportunities. I think there will be support for that. So, you know, again, the rather than painting a broad brush, I think the ANPRM does appropriately ask pretty granular questions.
Okay, well, so I just want to follow up just a real quick question to you, Adam, while I've got you. You had mentioned data minimization becoming a norm because of the GDPR, and that may be right. One thing I wanted to ask though, if there a tension between at the same time you're mentioning the benefits of targeted ads versus say contextual ads. You know, the literature is pretty clear that there's a multiple, whatever that multiple is, and revenue, which leads to arguably better content, more free content. Is there a tension between data minimization and the ability to use interest-based advertising, in the sense that, you know, at least as I read the ANPRM, they say, now granted, I think it's in the fact sheet, it may not be in the actual substance, but it's there in the zeitgeist of this document that if you use data to make your product better, that's okay. But if you use data to target ads, that may not be okay. That's a privacy issue. But the fact that I can target ads and I can gather more, so that would maybe not pass an FTC data minimization. Okay, well, you're gathering, you're gathering data that is then sent off to some ad network that then fills up an impression. That's data that we don't allow. Is there a tension there then between data minimization?
Yeah.
How do you make the two coexist, I guess, in your view?
No, I think there is a tension, and data minimization is one of these principles that doesn't have a black and white definition, right? I mean, so I do think we can and should argue, for example, about something like advertising, right? Because I think there are some who believe that targeted advertising is harmful. There are others, including me, who believe that advertising, while it can be pesky, is not typically harmful in that way. And that it actually provides benefits in the sense of helping monetize content that would otherwise require consumers to pay for paywalls, right? And so I do, or to, the creator, the dissident, right, whose content or blogging, et cetera, might be, indirectly supported through targeted advertising, news publishing creation. So I do think that, any principle around data minimization should definitely grapple with this question that advertising may be different. And I'm mostly reacting to, I think, particularly things like the Accountable Tech petition from last year, which was proposing a blanket prohibition on targeted advertising. That's not even really that's not even embedded in Congress's draft bill, right? And so my earlier point is I think the FTC will be on firmest ground politically, policy-wise, when it's looking for the gaps in current practice, as opposed to going further, much further than even Congress has been willing to go.
Well, thanks, Adam. So, Svetlana, let me move on to you with our next question, and of course, feel free also to weigh in on this issue of behavioral targeting and data used for advertisements. But what I wanted to bring with you is actually something that was brought up by Commissioner Phillips' dissent as well, is that the ANPRM at least hints at, and I think also in Chair Khan's statement, and actually earlier statements, is that the notice and choice model is dead or severely deficient, and that so we really need to move to something more like a data minimization or use constraints, not so much focus on notice and consent, but notice and consent has been the cornerstone of FTC policy really since the beginning of this. So I wanted to ask you is, do you think that the FTC should jettison the notice and consent? Is there a room for notice and consent in the future?
So let me answer the question from the preceding sequence, because I think it informs this question as well. So in terms of what rule the FTC should promulgate in terms of the trade-offs between the good uses of data and the bad uses of data, I think we need to kind of get down to first principles here in terms of what the FTC's authority is about. And so, as you know, FTC only has UDAP rulemaking authority for unfair or deceptive practices. So a deception is pretty straightforward. In terms of the unfairness test, unfairness requires substantial injury to consumers, which is not avoidable or outweighed by countervailing benefits to consumers or competition. So when we talk about the trade-offs, I think that's inherent in the unfairness analysis. The FTC can only promulgate a rule when it has reason to believe that the unfair, deceptive acts or practices are prevalent. So they have to make the prevalence showing, which means they have to show the practices, the deceptive or unfair practices are widespread. In order to make the prevalence showing, the FTC must either have issued cease and desist orders pertaining to such practices, or have other information available to the Commission that indicates a widespread pattern of unfair or deceptive practices. So I think those kind of first principles are important to keep in mind as you're evaluating what rule the FTC should promulgate. Based on the Commissioner's statements and the press event with regard to the rule, it seems that the agency is taking a different approach. It's asking the public to opine on what practices should be unfair or deceptive, or looking at the trade press or academic articles or other things in terms of what should be unfair or deceptive, rather than looking at the case law, the cease and desist orders, and the FTC's experience with unfair and deceptive acts or practices. So I think that's just something that struck me in my mind as I was looking at the statements and the press on this, is that the FTC majority is seeming to look at the public for their views on what should be unfair or deceptive. And I'm not sure if that is the proper frame of reference for this FTC rulemaking. With respect to your question on the notice and consent framework, It's not surprising that the FTC is trying to do something different than notice and choice. It's been for years now, that framework has been getting a lot of scrutiny, so it's not surprising. You know, the framework was discussed, you know, in the 2012 privacy report that said data collection should be consistent with the context of a particular transaction or the consumer's relationship with the business. It has to be consistent with what the consumer's expectation is. The advance notice takes kind of a different approach to consent, and even says that consumers may become resigned to data practices that have little or no actual control over what happens to their information. The advance notice also suggests that consumers do not generally understand data practices, such that their permission could be less meaningful, making express consumer consent to data practices irrelevant. So this will be an interesting departure from the 2012 privacy report to see how the FTC grapples with consumer consent. And also, I think it gets to these questions that Adam and Justin were responding to in terms of advertising, the beneficial uses of data, and so forth. So I think all of that will be interesting. In terms of use and collection limitations, to your second question, I wanted to start with the Section 5 framework because I think it informs the analysis. So from a collection limitation perspective, the FTC would have to show that there would be no legitimate use of that information where the benefits outweigh the costs. So a use restriction would arguably be more closer aligned or tied to specific harms rather than the collection limitation, because as we discussed, the data could be collected for beneficial uses or perhaps less beneficial uses. So a collection limitation might be more complicated. However, a use restriction might be more feasible in terms of the unfairness framework if you tie the use to the specific thing that is found to be unfair or deceptive, like, for example, stalking or cyberbullying or something like that. So I think the FTC might be on stronger ground to think about a limitation that could pass the unfairness test versus a collection limitation in the first instance.
Yeah, I think that's a really good point, kind of the distinction between use and collection, and how and teeing back of where you started your discussion, Svetlana, with this under the rulemaking that the practice has to be prevalent. And if you look at the FTC's long history of consents, and in the privacy domain, they are all consents. In data security, there are a couple litigated cases, but in privacy, they're all consents, is that there are very few cases that are brought as unfairness, and those tend to, where the use, and it's really about the use of the data. The collection of the data is almost always brought as a deception case, where the issue there is you lied to consumers to get their data in some ways. So if that's the record the FTC has to work with internally, this idea of, well, you know, is the practice prevalent based on the past, it will be an interesting hurdle to see. They're going to have to rely. I think you make a really good point about how they're going to have to rely on the record they develop here in rulemaking, not so much what they've done in the past if they want to go beyond notice and consent. But let me, Justin and Adam, give either one of you a chance to weigh in on this idea of, is the notice and consent dead? And then I want to pivot in our last bit here to the issue of algorithmic discrimination, which, or algorithmic bias, which is very front and center in this as well. But let's first, Justin, I'll ask you if you have any thoughts on notice and consent. Is it dead?
Yeah, I mean, I've struggled with this because you want to empower people to make decisions that maximize their utility. But in practice, I think we've seen with things either like privacy policies, which are meaningless, but even like forcing people to make choices, like GDPR consent screens, agree to cookies, choose what kind of cookies you want, is overwhelming and I think unwanted, and I think is not an optimal experience for anyone. And so I would think that's why you've largely seen advocates move away from like opt-in, right? That was traditionally what advocates advocated for, to this idea of banning, and I think banning collection, right, and not just again, this is like the seclusion. I don't want them looking over my shoulder. I don't necessarily care what they're doing with it. It's just none of their business in the first place. And there is like a record of a number of cases the FTC has brought, Vizio surveillance of smart TV information, Sears on browsers that were based on unfairness. And so I think that there is an argument for, like, this is a generally unwanted thing. People don't want to make choices about every single website selling their data or not. They just don't like it. Couple quick responses. I mean, I think one, like, the literature is actually, I think, not clear on this. There's not a lot of literature about how much value comes from behavioral targeting. A lot of it is very dated. The most recent, a number from Carnegie Mellon, about 4% value to publishers. Is that really worth all this? Also, I think empirically, you've seen ad revenues have plummeted as behavioral advertising has increased, and less of the surplus goes to the publishers and more goes to middlemen. So query if that really is good for publishers. Second, Adam talked about that Congress has not been willing to consider bans, but I mean, the bill that Energy and Commerce passed by a 53-2 bipartisan vote largely did ban online targeted advertising, not subject to opt-in or opt-out, like largely said, no, this is illegal. So I think there is some appetite for it. I think it's defensible. I think it's like a justifiable position. I think a fallback position that we have advocated for is global opt-outs, like let someone say, again, for every website, I don't want to make choices every time. Let me just say, for all y'all, don't sell my data. Don't let other companies collect it. That's the approach we've seen taken in some state legislation, like California and Colorado. Within California now is enforcing global privacy signals. That is something the FTC might consider. Say, okay, if you have evinced a desire, if you say you don't like this, then it becomes harmful for this data to be shared. And if you want more information on these ideas, we have a white paper on our site comparing these two approaches to a data minimization framework.
That's just kind of like native advertising, right? Advertising your white paper. Yes, yeah. I should have given that disclosure at this whole webinar was set up just as a vehicle for Justin to push his white paper. So job well done. Anyway, let me.
Can I just add one thing, James?
Yeah, I was going to move to you, Adam.
Sure. Yeah. Sure. So, I mean, I think Justin make a good point that, you look at things like the European cookie notifications, it's created kind of a habituation fatigue among consumers to if you look at kind of this debate, some kind of one poll says, well, we just do notice and choice and that covers it, right? Because consumers have their own right to contract and they can read these privacy policies. The other kind of extreme of that debate says, no, there's no way that consumers will ever know everything in that policy. They don't read them. And so that cannot be relied upon. I guess the thing I would say here is that, when you're trying to improve your fitness, you don't just diet or exercise. You should do both. You can both limit data use practices to avoid the worst, most problematic uses, but also preserving what's good about notice and choice and improving consumers' ability to make choices, right? So you think about just how radical, I think at the time, nutrition labels were on grocery items, but how much benefit they provide to consumers to help us make informed choices. I think companies have innovated in privacy information notifications. Think about how much better it is on an Android device or an Apple device to get that just-in-time notification of whether the service is about to, asking permission to use the camera or the microphone, comparing that to kind of traditional desktop, long terms of service, which I think most people would agree are working. So I think, rather than chucking notice and choice completely overboard, I'd like to think that there are ways here that the FTC or FTC rules might sort of encourage nutritional label type innovation in helping consumers kind of make more informed choices.
Well, thanks, Adam. And while I have you, I was going to pivot to this next question and start off with you anyway. So I've got you here. As I noted before, certainly another major focus area of the ANPRM is algorithmic decision making or automated decision making, whatever you want to say. So I kind of ask you the big picture question: is this a problem? And maybe I shouldn't. You're the only one on the panel who is not a lawyer. So, but I don't think you have to be a lawyer to be qualified to answer this question. How do you think Section 5 is the right vehicle to handle these discrimination issues, are they better left to actual discrimination laws that either existing or that Congress may pass in the future? So, Adam, I want to give you first
Yeah.
crack at this, but then move to all the other panelists as well.
I have to, I think there's Commissioner Bedoya has spoken quite a bit about this issue, not just about automated decision making, but about avoiding the problem of people's data being used against them in ways that are discriminatory to, again, deny them opportunities and jobs and education and housing, all kinds of things. And, I spent a dozen years at Google. My experience working in a company is that most people in companies, tech companies, want to do the right thing. There have definitely been plenty of exposés about how technology products and services have yielded discriminatory outcome. And my feeling about that is that that's not something that most people at the companies intend, or really anybody intends, and that it's appropriate for a rule to try to address this problem. Because again, I think there's probably widespread, a lot of agreement. This is something that most people don't want. They don't want to see their data being used against them to deny them opportunity. I think there's an opportunity here for the FTC to build on the existing non-discrimination laws that we have sectorally, which I think reflect a congressional view, but to say, look, we can be building on that by doing more, and frankly, incentivizing companies to test their own services to see if there is a discriminatory outcome, and then giving them an opportunity to cure. There's a right to cure, opportunity to cure in many privacy laws like California. So again, I think this is something most platforms don't want. They don't want to see a discriminatory output. Right now, there's a little bit of, there may be a little bit of incentive to test their own services. And so if FTC rules can encourage that kind of testing and curing, that could be a really interesting step forward for preventing the kind of discriminatory outputs that nobody wants.
All right. Thanks, Adam. So Justin, I'll go to you, and then Svetlana to this idea of algorithmic discrimination. It plays a big role in the ANPRM. Is it something that FTC should deal with under Section 5 or rulemaking, or is it better left to other existing rules that are on the books?
Yeah, I think it's definitely an appropriate area for rulemaking. I mean, algorithms intermediate more and more of our lives and makes more and more decisions about us. They are incredibly important. So I think it's appropriate that they ask a lot of broad questions about it. There are a couple different issues. Like one, I think is substantiation about, there's a lot of AI snake oil out there about companies overpromising and offering false precision about what their AI does. And that's, I think, very squarely in the FTC's wheelhouse. Like I brought a case, I filed a complaint against Spokio like a dozen years ago, which is a company that took publicly available data, generated unsubstantiated, let's say, credit scores for everyone, and FTC said no. You have to have a reason to believe that, and especially for credit scores, which are regulated by the Fair Credit Reporting Act. But there's also issues of bias as well, and they can concern that bias can be laundered into algorithms, and then there's lack of accountability. Oh, hey, the algorithm said that, you can't argue with it. It's science. I think Adam's probably right that a lot of cases it's not intentional, and the companies want to do the right thing, but the fact of the matter is, we have a historically biased society, and training training algorithms based on old data may again launder those biases into new systems. I know there's I may be getting the facts slightly wrong, so apologies to Amazon for this, but Amazon had a hiring algorithm that would rate candidates based on their previous based on previous Amazon employees, and it ended up saying the most important factors for being a good employee were playing lacrosse and being named Chad, or something that reflected potential biases in the systems that maybe did not take into account, did not generate the most fair results independently. And I think Adam said there's lots of examples that we've seen. I think it is appropriate for the FTC. Again, the FTC doesn't govern every single area, but things like economic opportunity, if a business is charging Black people higher prices than white people, then I think that's very clearly within the FTC's remit. And they have brought cases like that. They did a settlement against Bronx Honda last year, I believe, which is a dealership in the Bronx that was just charging minorities higher prices, and not no justification whatsoever. And so I think is the sort of thing the FTC, with their broad remit, should be looking at.
Yeah. Well, just before I move to Svetlana, one thing: the Bronx Honda case, though, was brought under the ECOA. Not under Section 5, and in fact, if I recall correctly, I think both Commissioner Slaughter and Chair Khan wanted to bring it under Section 5 as unfairness, but they didn't have the votes because it was a 2-2 commission. So so it was brought under a law that was actually designed to deal with discriminatory access to credit. This is, you know, and it was obviously contentious over whether this would actually be Section 5, and of course this rulemaking here would be under Section 5 unfairness or deception. We've got a couple minutes left. Let me spend a couple, maybe just briefly, Svetlana, I'll go to you, and then I want to leave a couple minutes for audience questions. We have a couple audience questions that we may want to get to, but I want to pivot now and ask about the relationship between this rulemaking and what's going on in Congress. Because you know, right now there's the American Data Privacy Protection Act, I think, ADPPA, that at least has gotten out of committee and seems to have some bipartisan support, at least the most support. I mean, every year it seems like there's going to be. I remember after Cambridge Analytica, there was going to be a privacy bill, and that didn't happen. But this seems to be the closest I've actually ever seen a privacy bill to coming to fruition in my. At least in my professional career. So I wanted to ask you, Svetlana, you know, what's the, you know, relationship between what, and I guess maybe you can't answer that because the ANPRM is sort of doesn't really propose a rule. You can read between the lines maybe, and more generally, and this was in Commissioner Christine Wilson's dissent. One of her rationale, she said, look, you know, Congress is considering this legislation that would actually give the FTC rulemaking power. So should the FTC wait until they actually get Congress to say, yes, you have the power to write these broad rules over the entire economy to deal with data, rather than going off on their own authority? So what do you think, Svetlana?
Well, with the time left, and I definitely want to hear what Justin and Adam have to say on these issues because they're closer to the Hill. But I mean, in my mind, I think the legislation and the FTC kind of take at least their first principles kind of diverge in terms of corporate surveillance versus privacy and consumer protection. You know, for example, the federal bill doesn't refer to commercial surveillance at all. The advance notice of proposed rulemaking and the congressional legislation both acknowledge beneficial uses of data, but the advance notice downplays the informed decisions that the public could make about beneficial uses of data. The congressional bill notes that the beneficial uses must be considered when creating exceptions to alleviate burdens on covered entities. They also have differing approaches on teens, which is, I know we wanted to get to, but probably won't have time. You know, the FTC takes the position that it may be unfair for companies to fail to maintain privacy settings by default, even when the site is not targeted to minors, whereas the congressional bill only prohibits targeted advertising to a known child. So there are key distinctions between the two, which kind of shows kind of the starting points might be a little bit different and distinct, but I'd love to hear Adam and Justin on this question as well.
Yeah, so Adam, let me turn, we got a couple of minutes left, and this will allow me to actually maybe tie in one of the good questions that we got from the audience that kind of tease off. There was a Wall Street Journal editorial this morning about the FTC and kind of its hostile legal environment that it's in, for lack of a better word. You know, there are various cases bubbling out there that actually go to the core of independent agencies' constitutionality. There's a case called Jarsky. The FTC suing Walmart in completely non-privacy related, but the Walmart issued a motion to dismiss that challenges the constitutionality of the FTC, or at least the ability of the FTC to go into court and get monetary penalties, regardless of what, you know, basically the Magmoss rulemaking authority would be unconstitutional, or at least the ability to get fines off of that rulemaking authority would be unconstitutional. So there's the Axon case. There's a lot going on, and they just lost in AMG, a year ago. So is this the right leaving? In addition to the idea that Congress is working now, there's also a very hostile environment out there for the FTC, a legal environment. Is this the right time for the FTC to say, hey, let's dust off Section 18 and embark on this giant rulemaking? Or do you think they're better served waiting to get explicit authority from Congress?
My own view is I think it's fine for this debate to unfold on a dual track. There's going to be a lot of argument. There's already a lot of argument about whether the FTC has the legal authority to do this. That's going to continue. And that will, frankly, probably not be resolved until there's a court challenge to whatever the FTC comes up with. I view that as inevitable. That won't be litigated for years. But in the meantime, the other track is to have a debate about what should be in the rules themselves. And I don't think people who are concerned about kind of good policy here should abstain from that debate, even if they believe the FTC lacks the authority. I do think, to Svetlana's point, the FTC will have the most political support if it focuses on the areas of the ANPRM that around which there is probably the greatest consensus. I know there are some who kind of want to kind of pursue a maximalist agenda. Now that after the Trump years, let's do our as a Democrat, let's do our own maximalist agenda. But I don't think that's likely to succeed. And as Svetlana noted, that even members of Congress recognize the beneficial uses of data, and I think have taken a more modest approach. I think the FTC will be most successful if it kind of follows Congress's lead. I don't think there's any problem with them doing a bill, but I think following the signals that Congress has sent will I think increase the support that they have for whatever rules they come up with.
Well, thanks. Unfortunately, I think that is going to have to be the last word. And I don't mean unfortunately. That was a good last word, Adam. You did a nice job of kind of wrapping everything up. But we're already at 1:01, and we'd like to end things on time. But I think broadly, your point about the actual legality, the legal authority for the FTC to do this, probably more the admin law question, which is different from what we're thinking about here. That's going to be really one of the first questions that's going to be addressed here, apart from all the substance the very interesting substantive policy debates around privacy that we spent barely to scratch the surface on. But let me thank everyone. This has been a really fantastic panel. And like I said, I think we just really scratched the surface here, but I learned a lot, and I'm sure the rest of our audience learned a lot too. So Svetlana, Justin, Adam, thanks a lot for your time. It was fantastic. And thanks all of you in the audience for listening. This will be posted on the PEP website if you missed anything or you want to spread the word. Send this to all your friends and family to watch as well. So again, thanks everyone. Have a great rest of the day, and go Francis Tiafoe. That's what I'll end it. Our DMV tennis hero who's up there in the battling for a semifinal berth. Go Francis. So, all right. Take care, everyone. Thanks.